Now let's talk about doing a deed in lieu of foreclosure. A deed in lieu of foreclosure is when the borrower agrees to give or deed title to the property to their lender in exchange for being relieved of their obligation to repay the remaining balance of the loan. If a borrower is going to ask for a deed in lieu, it is very important that they make sure that the lender agrees in writing to release them of all future obligations to repay any deficiency which results from the deed in lieu agreement. To accept a deed in lieu of foreclosure, the borrower must agree to vacate the home in a reasonable time, which is usually between 30 and 90 days after the agreement is signed. Generally speaking, to qualify for a deed in lieu, the fair market value of the home should be somewhat close to the total amount of outstanding mortgage debt, and the property should not be subject to any junior liens. If you have junior liens on the property, it is very unlikely that your lender will agree to a deed in lieu because they would be taking the property back subject to the junior lien obligations, and they won't do that. Most lenders these days don't want to take any more property back on their books anyway, so they often require that borrowers attempt to do a short sale of the property first before they will even consider doing a deed in lieu. So, what are the potential benefits and drawbacks of a deed in lieu? Well, if a lender agrees to it, a deed in lieu of foreclosure is the fastest way the seller can get out from underneath their distressed property. Some sellers may also be able to deed it back to the lender without having to go seriously delinquent on their payments, which could help save their credit score. It is also a much less expensive process for the lender versus foreclosure because they do not have to pay for real estate, commissions, and closing costs associated with a short sale or lawyer's fees associated with a foreclosure sale. The one downside of a deed in lieu, if you want to look at it this way, is that it does not give the borrower the opportunity to live in the home for the next 6 to 12 months while saving the money that they would ordinarily be paying towards their mortgage payments. This money can be very helpful to homeowners who are in preparation for the transition which will occur when they do ultimately lose their home to foreclosure. If you agree to a deed in lieu with your lender, it is very important to have an attorney review the agreement before signing it to make sure you're not signing something that is not in your best interests. To contact an attorney in your area who is familiar with all of the issues related to distressed property and deeds in lieu, who is part of the shortsalecircle.com community, please click on the attorney icon on this page.